able to hear me? Everyone can hear fine? You can see the screen okay? Welcome to the Community Law Resource Group Darnum meeting for November. There'll be one more meeting in here in Darnum next month, and then that'll be it for the year.
He told me the last one. It was the last one.
No, Ashburton is the last one.
Okay.
Ashburton is the end of November.
There's notices if people want to take away with it. It's got next month and February on it too.
Oh, you're right.
Put down 3 months at a time, you see, so that it's...
If someone wants some notices, they're here.
Yeah.
And if you know anybody who's interested, please take. Give them. Sick and tired of driving around all over the place.
No worries.
I've got some. I'll take some of that. I'm in screen
I might get one too, Darryl.
Ringing up the court.
There you go, I've got plenty.
How'd you go ringing up the court?
I sent her off today, registered post.
Oh, did you?
In a writ of promo and post.
Now, what about, is there a warrant? Did you ring them up about that?
Well, they told me 2 weeks ago there was.
Oh, okay, I thought you were going to ring them up.
Yeah, no, I'm ringing them up again. No.
Okay, who's here for the first time? Okay, we've got 2 here for the first time. Community Law Resource Group is to be formed to help you understand what government can and cannot do, and where your rights lie, and how to interact with government. The biggest problem we have in this country at the moment is the people are too disconnected from government. Now, government is a word that's used and abused way too much. Government is made up of 3 tiers. You've got your executive, you have your parliament, and you have the judiciary. Those 3 entities must be separate. One cannot influence the other. And this was established at the beginning of the 20th century in what's called the Commonwealth Constitution. And the Commonwealth Constitution lays out what each of those entities, what their task is, what they can, what they cannot do. And it's important that we the people wake up to what that document says, because there is a key section in there, section 109, well, first section 5 of the preamble, which is up on the board.
You want to go back to the beginning of the preamble?
Yeah, good point. Yeah. Okay, that's the beginning of the Commonwealth Constitution. And it lays out quite clearly there that the people...
This is the Constitution Act.
Constitution Act.
I should quickly explain to people the difference. I know we did a little bit last time. There's the Constitution Act, which has 9 parts. Section 9 of the Constitution Act is the Constitution itself.
Okay.
So there are 9 sections in the Constitution Act. And this is the preamble to the Constitution Act. And we'll deal more with the Constitution Act in a minute, and then we'll be going on to the Constitution.
So, the beginning of the preamble starts off, whereas the people of New South Wales, Victoria, South Australia, Queensland, Tasmania, humbly relying on the blessing of Almighty God, have agreed to unite in one indissoluble federal commonwealth. Okay, we're about to be confronted with a referendum fairly soon, which the current government is going to be asking to include the Aboriginal people into this preamble. Can you see any discrimination in those first three words? Why would there be any inclusion of Aboriginals?
Why were they excluded in the first place?
But the thing is, the word people doesn't discriminate. It covers everybody. Okay. So we've got a problem straight away. But we need to understand what those first three words mean.
Very, very powerful words.
Very powerful words. So, that first paragraph also establishes the sovereignty. True sovereignty lies with the people. So you're the master, and the government, all entities within the government are the servants. Okay, so that's very important as well. But in fact, that first paragraph, there was a lot of debate went into that first paragraph, and this constitution was meant to reflect the laws established in the Bible. Okay. And the word Commonwealth also comes straight out of the Bible. Okay. So it's pretty clear that where the jurisdiction lies with this document. This document was made up from three countries: Switzerland, the US, United States, and England. Switzerland, we inherited the referendum rights. The US Constitution, especially with respect to court behaviour. Also, the laws of England apply themselves in our courts as well. Now, Section 5 of...
People is really interesting to me because it's just people.
Yeah.
So it's not the electors or the voters or ratepayers, including all the children and everybody.
Everybody. It's no discrimination.
What it also does, it gives the people the ultimate authority. That's the powerful bit about it. It's us, the people, the children, everybody here and everybody else are the supreme beings in the Commonwealth of Australia. Not the federal parliament, not the police, not the army, no one. The people. Whereas the people. That's why it's worded that way. Very, very powerful words, those three words.
It doesn't discriminate where you came from either.
It doesn't. It's no
everybody
discrimination in any way, shape. Yeah.
No ethnic discrimination, racial discrimination is with the people of those states.
Yep.
And Western Australia was included just after this. So a lot of people ask, why isn't Western Australia there? Well, at that stage they hadn't conformed with by means of referendum, but they did later on. Now we're going to Section 5. Remember how I said there was 9 sections to the Constitution Act, and we're now going to 5. This is, we should explain why this is relevant, I suppose.
Yeah, well, it's self-explanatory, really. This Act and all laws made by the Commonwealth by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state. Now, keeping that in mind, the Parliament within this Constitution are restricted as to what they can legislate. This Constitution was an experiment. In England, Parliament exercised what's called parliamentary sovereignty. Okay? So that when either one of us chose to stand in Parliament as a representative of the people, then we took our sovereignty, that power, into the Parliament, and therefore made laws. So in England, they didn't need the permission of the people. They do not have referendum. Now in Australia, when they drafted this constitution, and they started the debates in about 1890, 1891. Now those debates formed the foundation for this constitution, so they are to be read in conjunction with it. The Hansard for those debates are available. And in that Hansard, they actually debated the parliamentary sovereignty question. And they said, we will not allow any parliament in Australia, state or federal, to exercise any form of sovereignty. They are to be known as constitutional parliaments, which means they are restricted as to what they can legislate. Okay, so that's imperative, and this is something that this system have eventually whittled away, unlawfully and without our permission. Okay, the first attempt was 1942 with the Statute of Westminster, and that's when the first started to creep in that the Parliament had sovereignty, and then they slammed the big hammer down in 1986. Okay, and all of our parliaments, state and federal, assumed sovereignty. Okay, now that's in breach of this.
Now, I wasn't aware of it. One of my friends 2 weeks ago was on a vintage car rally up in Canberra. Among other things, he did a tour of the old Parliament House. And there, prominently, and most importantly on display, together, an original of the Constitution and an original of the Magna Carta.
Oh, they got one of the new ones.
So I'll try and get a friend, one of my ex-school friends, to go along and take some photos or some digitals of it, because that could be handy in argument sometime, perhaps.
Well,
it would have been handy with Robert Clark there the other week.
in fact, on the High Court, on the windows of the High Court in Melbourne, they have a Magna Carta.
I saw them in the new Parliament House.
Yeah.
An original copy. You think, oh, well,
Yeah.
the originals are in there.
But they take absolutely no notice of it. And they're only allowed to do that because we don't know. We need to wake up. And this is why we do these meetings. This is why we're here to help you understand what government can and cannot do. Now, a valid section of the Constitution is section 109, and that's a direct instruction.
Of this, the significance of this for what we're going to talk about tonight is someone who gets a speeding fine, and they go along to the magistrate's court, and the magistrate. We'll fix that real quick. You go along to the magistrate's court, and they don't want to know anything about the Constitution or federal law. That's why this is significant. He doesn't have a choice. And any documentation that says to the contrary is invalid to the extent of that contrary, which is what 109 is going to show us. So what that's doing is saying that the Constitution and laws made by the Parliament are applicable in this this magistrate's court, the same as every other judge. So I just sort of, before we go off, I want people to get that. This Act and all laws made by the Parliament of the Commonwealth under the Constitution. Now there's several things that are important there. This Act and all the laws made by the Parliament, of which we're going to go on to one shortly, made under the Constitution. In other words, if it's not made consistent with the Constitution, it's not a law. And all the laws made, the Constitution and all the laws made by the Parliament are relevant to whatever court you want to go into. That's the point of what we're trying to do. Well, it'll come up. Sorry.
Whether they like it or not.
Whether they like it or not.
There's a lot of judges that don't want to hear about the Constitution, and they start cracking up as soon as you bring it up.
This is where what we've got here, we've got two laws in this country. We've got state law and we've got Commonwealth law. And